Welcome to my next video in my Idaho 4 series, and today we're going to be talking about the newly passed amendment to SB 1250, the public records exception that Olivia Gonzalez worked on tirelessly and finally got passed. So let's get right into it. This is Olivia's speech.
My name is Olivia Gonzalez. I stand before you today as the sister of Kaylee Gonzalez and Madison Mogan, murdered together along with Ethan Chapin and Xana Knodel in their home on November 13th, 2022 in Moscow, Idaho. I'm not an expert on much, so I won't pretend to be. I'll just be me. I wanted to offer you something personal, a little view into the mechanics of the system as it exists in Idaho as a family member of a homicide victim. Shortly after sentencing, we were told it would be months until anything came out. Documents, photos, filings. We welcomed the temporary halt on what had already felt like a nonstop assault since November 13th, 2022. If the loss or the grief or the longing doesn't beat you into exhaustion and submission, the justice system surely will. We welcomed the end. But that's not really what happened. You see, in my sister's case, a non-dissemination order had been put in place, and once it was lifted, the floodgates opened wide. People waited, but just barely, foaming at the mouth for answers they felt entitled to. And when the first scene photos released, they were everywhere all at once. Within an hour, they were unavoidable. I opened my Facebook app not knowing what I was looking at. My stomach sank, my heart rate spiked, and the panic set in. I was the one to call my mom, my dad, and Xana's sister. All I could say was to stay offline and turn off the TV. The damage was done. They were already being shared far and wide beyond just the taxpayers of the United States. It was a sunny Friday afternoon in August, after business hours. There was nothing I could do. What once might have been a document viewed briefly in a courthouse can now become an endless digital echo, reshared, sensationalized, and weaponized in ways lawmakers decades ago could not have imagined. The internet has fundamentally changed the consequences of releasing sensitive materials, especially images of bodies. I know that's hard to hear, but I need to repeat this. Photos of bodies of our loved ones should not be released publicly. I know you might sit there and think that that would never happen, but the current statute is vague and leaves this open to interpretation of the law, once again placing victims in a position of begging for mercy. Senate Bill 1250 recognizes this reality. It acknowledges that vague language written before the age of instant global dissemination no longer provides adequate protection for victims or their families. But I want to be very clear about something equally important. Families should not be shut out of access to the truth about their own loved ones. I want to share something now that I have still not yet been able to articulate verbally. On July 23rd, 2025, Moscow Police Department released 578 pages of documents, including reports from the first officers on scene. Nearly everything within these pages was new information to us. No one told us these things. We didn't know these things. Kaylee was described using the following words and phrases. Kaylee was unrecognizable, as her facial structure was extremely damaged. One female on the left side of the bed, in relation to the bedroom door, had an extreme amount of lacerations to her face and upper body, which made her unrecognizable. One female showed an apparent traumatic injury to her face due to the basic facial structure being unrecognizable. Her face was completely disfigured and was stabbed several times. I was unable to comprehend exactly what I was looking at while trying to discern the nature of the injuries. The mental images created by these photos, by these words, were horrific. My fear of the unknown was further compounded by intense public interest and a very real possibility these photos might one day make their way to the internet. I made the decision to request a sit-down with prosecutors and investigators so I could at least control something. I wasn't ready, and I didn't want to, but I prepared the best that I could. I was with investigators and prosecutors when I saw my sister. Though I have grown to love them very much, I truly just wanted privacy with her. I refused to cry, and instead tried to lighten the mood by commenting on how pretty her toenails were, her painted toenails were, how her tanning lotion made it look like maybe she could even still be alive. You see, I know that these photos hurt them too, and I didn't want to hurt them anymore. I was shivering now, but not from the cold, and viewed only what I felt I could manage in the moment without breaking my composure, desperately trying to find a balance in harm reduction for us all. But if I'm being honest with you all here, all I could really think about was how much I wanted to curl up with her. If they had just called me when it happened, I could have brought her back to life. How beautiful she was, and how it was very much so Kaylee. There was nothing disfigured or unrecognizable to me. It was just my little sister. As we went through more photos, I would quietly think of how I would comfort her had she lived. That's just a little scratch, Kaylee. With a good surgeon, it won't even scar. It will be okay, Kaylee. Veneers have come really far. I'll get them with you even if you want. It's okay, Kaylee. I can fix all of these things. I can fix you. If I'm being honest with all of you here, I just wanted to hold her. I wanted to tell her how loved she was. I wanted to make fun of those silly little officers who wrote those silly little things about her. They were mistaken. You are not those things, Kaylee. You are just my sister, and I'd recognize you anywhere, no matter what. I remember thinking I violently needed to know that the officers and medical staff spoke kindly to her, that they told her that she was okay now, that they were gentle with her, that they took care of her like she was their own sister. Because what if she was your sister? Those mental images still exist. I can see them now even, but I now know that they don't carry any weight. There is no truth to them, only fear. I don't know how I would be coping today without that distinction. I am not a spectator. I am not an outsider. I will carry Kaylee and Maddie with me forever, here on Earth and for whatever comes after. Protecting sensitive materials from public exploitation while preserving appropriate access for families is not contradictory. It is a compassionate balance. It says that Idaho understands two truths at once, that technology has tipped the scale of harm, and that families should never become collateral damage in the effort to protect it, to prevent it. I speak today not only for my sisters, but for families who will walk into courtrooms years from now, families who don't yet know their lives will change overnight. They deserve laws that anticipate their needs, that reduce harm, and that reflect compassion alongside accountability. We cannot rewrite what has already happened, but we can decide what happens next and who the system is built to serve. Senate Bill 1250 does exactly that. I respectfully urge your support. Thank you.
Point. So then why is that not your fight? Why is that not your entire freaking testimony about how y'all were lied to, about how information was kept from you? Why are you instead coming out here and being poetic and telling us that these silly little police, these silly little boys had it wrong in their police report? You looked perfect, Haley. Not a problem. What are you doing? That should have been your entire speech, was how lost you were. The fact that y'all had to rewrite your impact statements today, that you were supposed to face Koberger in court. Why isn't that the argument then? Because that is part of the bill. We're going to go over the bill here in a minute. I have it all highlighted, what we're going to go over that was included with this, because this section about photos of the bodies is literally number 24 at the very end of the bill. There is a portion in there about families getting access. Why is that the majority of their fight? Why is that not what they're talking about the most? That's been their public fight for years, not getting information as a family. So why is that not what their main argument is in these testimonials? This is the most backward shit.
And it's difficult to remember. Taking point.
That Senate bill that Kaylee's sister was trying to get passed, it's going to happen and it's going to become law July 1st. They posted, we got some great news. For months now, Olivia's been working hard on Senate Bill 1250. She's testified twice, has been to several meetings. Today, Idaho Governor Brad Little called her and told her that he was signing the bill. It will become law on July 1st. So what this means is that photos of descendants' bodies will never be released to the public. It is no longer part of being public record, and it cannot be FOI 8. Families and family only may request the photos. Now, a little more detail on that bill. It directly affects anyone in the world who wishes to request certain death scene photos from Idaho government agencies. While the law only governs records held within the state of Idaho, it effectively blocks everyone, regardless of where they live, from obtaining these specific images through a public records request. Now, I saw people asking that, even though it's passed as of this month, it's scheduled to go into effect July 1st, so they're like, can requests still be made up until July 1st, or is this it, now that it's passed in March? Anyway, so how do y'all feel about this? Well,
Do you realize that she's coming out here telling everyone that the reports don't match what she and only she has seen, while telling us, too bad, you can't see the proof of that anyway. What I saw didn't match everything that those silly little cops said about Kaylee. I'm sorry? Everything is alleged. All of the proof for everything that I'm about to question here is on my YouTube channel. We went over this in a live on the night of 3/28/26. I don't have an issue with 1250. I don't have an issue with bodies not coming out. We had one slip up, if you want to call it that, with Xana's body not being fully redacted in the ISP photos. They realized their mistake and they took it down. There was already some sort of regulation in play that made that a bad thing, which is why it was removed. And as far as I can tell, they've never actually put it back. They've never corrected the redactions and put it back up on the public website that ISP put out there so that they could release photos and reports. When Olivia first came out and told us how she met with the prosecution in October of 2025, she said she saw one photo, that Maddie was redacted in the photo, that they offered to show her more, but she just couldn't do it. When she came out to give testimony for 1250, which is the new law that just passed, she is saying that she saw more, that it affected them greatly, everything that she saw, that she wanted to protect other families from dealing with this. But this is the problem that I have. She only saw Kaylee because she asked to. It wasn't released out to the public, and she saw it on the internet the way that the crime scene photos themselves are out there. When it comes to her physically seeing her sister, she asked for that. She's sitting there saying that the police reports that talk about how Kaylee's face was so disfigured that she was unrecognizable, that it's just these silly little boys, these silly little cops and their silly little words, and that once she saw the photo, she realized that that mental image that those silly little words from those silly little cops put into her head about what Kaylee looked like wasn't true. Do you realize that she's coming out here telling everyone that the reports don't match what she and only she has seen, while telling us, too bad, you can't see the proof of that anyway. Trust me, bro, what I saw didn't match everything that those silly little cops said about Kaylee. I'm sorry, is the report wrong? Or are you being metaphoric and poetic when this is supposed to be about actual facts? Why are you coming out here and telling the entire world that all of these reports that describe everything you yourself has said to us about Kaylee's injuries? Her family came out here and said that because of her facial injuries, her cranial injuries, that itself would have taken her life. You've come out here and described her the way that the police saw her. Now, in this narrative, you're sitting here saying things about how once you saw the photo, that mental image that those words put into your head was gone because it was so incorrect. That's not cute to be coming out here and saying, well, then saying, but we're not going to let you see it. I'm going to come out here and tell you that what it says isn't what I saw, but oh well, you can't. While saying that you are demanding transparency, while complaining about how this case went. The back asswardness, or whatever you want to call it, of these people is insane to me. And I need some clarity. Some clarification about what do you mean. Please and thank you.
Lay down and I don't mean to get vulgar or anything of that nature, so I'm gonna clean it up a little bit. Are we just gonna lay down and let them screw us? Because this is the beginning, folks. Mark my words. One day you're gonna look back on this stream, the people that were here, the people that listened to it, the people that were curious about what Phoenix talks about. We're gonna lay back and we're gonna look back and we're gonna think, shit, it started in Idaho and it just domino effect all freaking over the United States. Seriously, are we just gonna sit back and take this bullshit? I know I won't in my state. I write my congressmen. I know who my representatives are locally. I go and I email them. I talk to them. I go to events that they go to every single opportunity I get. And I will tell you, it's been a little while since I've done that. Different health issues and traveling. But it is so important that we stand up for things like this. This is not about freaking, this should say a lot about the Idaho 4 case, guys. This is not about just the victims. This is about control and power. That is what the Idaho 4 has been since day one. If you thought something was wrong with this case, this is how precedent is changed in the court of law. They use it in court cases to go and further their agendas. And I cannot begin to tell you, whatever the hell is going on in Idaho, we need to talk about it. Seriously. We need to talk about it. They had just said, now we're going to not tell you the truth. Okay? And this.
So I wanted to put the videos of like Phoenix and Jules after what Olivia said, because I wanted you guys to see the constant hate and beratement that the Gonzalez family faces on a daily basis. And for Jules in particular, hates that family so much for absolutely no reason. And I cannot seem to find a reason why. I've watched very few, well, not very few, but a few of her videos, and they are just her screaming at the screen about conspiracies and the Gonzalezes, and trying to find minute inconsistencies in what they say to somehow prove that the narrative is wrong. And I remind you that this is a woman who claimed she had a criminal justice degree, but yet did not. So she lied. Now, I don't know if she's being purposely obtuse by saying what she's saying about Olivia, when she's saying that that she viewed the pictures and then she decided that that didn't match up to what was in the reports, because it's very clear from Olivia's testimony that she gave that she was being metaphorical. That when she saw the images of her sister, despite the numerous injuries on her sister's face, she knew it was her sister. She could tell it was her sister. And while she may have been unrecognizable to people who did not know her, she would always know that that was her sister, despite those injuries. That is clear to literally everybody. And I don't know why Jules is trying to mince words and make it seem like now the Gonzalez's and Olivia specifically is trying to tell the world that the police reports are wrong and that the narrative that we were given is incorrect. That is literally being purposely obtuse and lying and spreading misinformation to try to get everybody up, all riled up for absolutely no reason. Because it's very clear from Olivia's testimony, what she is saying is that even with those cranial injuries, even with the stab wounds to her face, she knew that was her sister. And there was nothing unrecognizable about her. Because despite all of that, she would always recognize her sister because that is her sister. And that gave her peace, despite what she was looking at. So you make your own conclusions about what these creators are saying about these families and this bill. You can read through those comments. You can pause them, go back and look at them. But I wanted to just show you, before we get into the nitty-gritty, about why there are no issues with this amendment to SB 1250, because I want you to understand that there is conspiracy theorists out there that continually spew this hate, and it goes on and it goes on and it goes on, and then things get catastrophized, and then we end up in this situation where I have to make a video explaining to you why this is legal and why there are no issues with this. So now let's get into the nitty-gritty of it, all right? Senate Bill 1250 in the state of Idaho, okay? And this relates to records exempt from disclosure, okay? And they're amending the section, okay, to provide that certain records shall be exempt from disclosure, to provide an exception, okay? And to define a term and declaring an emergency and providing an effective date, okay? So now what this particular means, okay, and I put on the, well, it's actually this side, over in the corner, SB 1250 already existed, okay? So I can't tell if some of the creators didn't know that, but SB 1250 already existed, all right? And what they did is they added this portion, okay, portion 24, okay? Jules, for some reason, thinks that, like, why they put it at the end? It's number 24, like, whatever, okay? It's 24 because it's the newest addition to the bill, okay? They added this portion at the end because it's the newest addition to it, okay? It's an amendment to SB 1250, okay? And it very clearly states that the photographs and images of the decedent taken as part of a coroner's death investigation or law enforcement investigation, regardless of whether such investigation is active or not, okay? They cannot be released to the public, okay? And they can only really be released to next of kin, okay? That is what this means, all right? It was added to an existing bill to expand on it to include this type of information, all right? The bill already existed. There are already a bunch of other things that are not released, like medical records and things like that, attorney-client work product, all of those things. You can go and you can read the bill in its entirety, but this underlined portion is the portion that was added to the bill, okay? Now we're hearing it's the First Amendment, the First Amendment, the First Amendment. Why are you blocking free speech? This has nothing to do with that, okay? And we're going to go through case law, actual case law. All right, sorry, I have to adjust myself for a second. Actual case law that tells us why this is legal, why you can do this, and why courts have found that this is an acceptable form of redaction. All right, so let's go over what the First Amendment is, okay? All right, for those of you who like to cry about free speech, all right, Congress shall make no law. I actually have to zoom in a little bit because I can't see. Whew, wow, I'm blind. All right, let's see. Respecting an establishment, making a law respecting establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or the right of people peaceably to assembly and to petition the government for redress of grievances. Sorry, I had to zoom. My eyes are really bad. And I'm very tiny in this little bubble. Okay? Now, the First Amendment protects against the government censorship of ideas, not all forms of speech in all contexts. Okay? Now, it's against government censorship, not like me trying to censor you or you trying to censor me. Okay? It's government censorship, government infringement upon your rights. Okay? Categories of speech that are not fully protected because there are certain enumerated categories that are not protected. Okay? There are things you cannot do or say. That is true threats. Okay? Like, I am going to unalive you. Okay? Incitement. Okay? And that is from a Supreme Court case, Brandenburg v. Ohio. All right? Harassment. Not considered free speech. Speech integral to criminal conduct. Time, place, and manner restrictions. Okay? Free speech is not a free-for-all, and it never has been. Okay? People seem to think that speech is protected always, and that is not the case. Okay? Social media amplifies these bad legal takes, and then people get it in their minds, and then they're stuck with them. Emotional reactions are not greater than legal analysis. They're not greater than legal analysis. Okay? Constitutional law has never been about the vibes. It's never been based on vibes. It's based on precedent. And there is a lot to support SB 1250. Okay? What SB 1250 actually does. All right? The law restricts public access to certain death-related images like autopsy and crime scene photos. It is not regulating what people can say. It is regulating what the government is required to release. There are already protections under SB 1250 that protect the release of other private information. This is no different, okay? This restricts public access to certain death images, as I've already said, okay? The government decides what records are public, and legislatures can create exemptions for privacy, safety, and dignity. And you're going to see that privacy, safety, and dignity be repeated in a couple of the cases that we're going to go over. Just like medical records aren't public, not everything the government has is automatically yours to have, access, and discuss. SB 1250 is addressing the exact category of material people in high-profile cases often try to obtain. Okay? If you remember correctly, a certain content creator, who you all know, obtained death images of a certain child and then charged people money to view them. Okay? This is something that is being done to protect from that happening again. All right? Because that's disgusting, right? We shouldn't be doing things like that. All right? there are differences between wanting answers and demanding access to deeply private images of someone's loved ones. All right. Now let's go into the constitutional right to government records. There is none. There is none. The First Amendment does not create an affirmative right to obtain autopsy photos or death images, and let's review the relevant case law. Okay? Let's review the relevant case law, because I come with facts and I come with case law, because you're not going to sit here and tell me that I'm wrong, because I'm not. Okay. First, this has to do with family privacy rights. This comes from the National Archives and Records Administration versus Favish. This is a 2004 case. It is a U.S. federal case. Okay? It's a Supreme Court case to be specific. The United States Supreme Court established in the National Archives and Records Administration v. Favish case that FOIA recognized surviving family members' rights to personal privacy with respect to their close relatives' death scene images. Okay, so this is a case right on point. Okay, the United States Supreme Court says that FOIA recognizes surviving family members' right to personal privacy with respect to their close relatives' death scene images. Sound familiar to the language in 1250? Yes. The court explained that family members have a personal stake in honoring and mourning their dead and objecting to the unwarranted public exploitation that, by intruding upon their own grief, tends to degrade the rights and respect they seek to accord to the deceased person who was once their own. The privacy interest is rooted in cultural traditions respecting burial rights and common law protections, allowing families to control the body and death images of the deceased. Sound familiar? Sound familiar to some of the language in the Idaho statute? Dignity, respect. Okay? Constitutional validity of autopsy photo disclosure restrictions. So it has been challenged, okay? And there is a constitutional validity of restricting the disclosure, and that comes from Campus Communications Incorporated v. Earnhardt. Okay, I think you can obviously get from which terrible incident happened that spawned this one. Okay, courts have consistently upheld statutes prohibiting disclosure of autopsy photographs against First Amendment challenges. In CC Inc. v. Earnhardt, the Florida District Court of Appeals held that Florida statute exempting autopsy photographs from disclosure under the PRA was not unconstitutionally overbroad. The court found the exemption met constitutional requirements because it was supported by a thoroughly articulated public policy to protect against trauma that would likely result if such records were disclosed to the public. The legislative findings detailed the graphic and often gruesome nature of such autopsy photographs and the trauma and emotional injury that would likely result if records were disclosed and disseminated to the public. Now, I know what you're going to say. You're going to say, well, this is a Florida case. This is not binding precedent on Idaho, okay? But it can be cited as commentary, okay? It can be cited as precedent, not binding, but it can be cited as precedent. The U.S. federal law, same thing, okay? And this is what they use to make the determination on how other states have viewed these public records exceptions. And this is how they came to the conclusion that what they did in Idaho and making sure that these deceased photos, the photos of the decedents are not released to the public, this is how they came to the conclusion that it was constitutionally valid. Okay? First Amendment does not require disclosure. Shuttleworth v. City of Camden. This is a New Jersey Supreme Court case. Okay? The First Amendment does not create an affirmative right to obtain autopsy photographs or death images. In Shuttleworth, the New Jersey court held the First Amendment did not require disclosure to newspaper of autopsy photos, where public had no right to obtain disclosure. The court explained that while the press acts as the eyes and ears of the public and cannot be prevented from publishing information it acquires, it is not entitled to obtain information to which there is no right of public access. Okay, and Shuttleworth is one of the first cases that this sort of ends up being an issue for, because obviously we're talking about when things started to becoming more popular. 92 is when the internet started becoming more popular. People started getting computers. They were becoming more, not a lot of people had computers in their home in 92. I don't think I got a computer in my house until maybe 96, I think, maybe. But things are becoming more available, okay? State statutory framework. Multiple states have enacted statutes specifically exempting autopsy photographs from public disclosure. Florida law provides that autopsy photographs shall not be subject to disclosure under the PRA, which is similar to Idaho's, which limited exceptions for good cause shown. California law prohibits reproduction or dissemination of photographs taken during postmortem examinations except for specific purposes, including criminal proceedings and civil actions related to death. These statutes reflect the legislative determinations that families' privacy interests outweigh the general public's access rights. Okay? The balancing test relates to FOIA context, okay? Because I know a lot of people are saying, well, like we can FOIL it and we can get it and we should be able to get it under FOIA because we should be able to get everything. That's not true, okay? Prison Legal News versus Executive Office for the U.S. Attorneys, obviously another federal case. Federal courts apply a balancing test under FOIA Exemption 7C when evaluating requests for autopsy photographs. In PLN versus Executive Office for the U.S. Attorneys, the 10th Circuit held that a family's strong privacy interest in the images, was distinct from the publicly disseminated written information about the images, and that disclosure could reasonably be expected to constitute an unwarranted invasion of personal privacy. An unwanted invasion of personal privacy, because they're always going to weigh the personal interests of the individual, okay? The court emphasized that although written descriptions of the murders were widely publicized, the images were viewed only by limited numbers of individuals who were inside the courtroom for the murder trial. All right. Now, if you've ever watched court TV, when they put the images of like the dead bodies up on the screen, they don't show those to you. They turn the camera away. This is very similar. The balancing test in Idaho's public record context. Okay. So this is in conjunction with all we just talked about with Idaho's PRA. All right. Idaho's PRA contains parallel protections. Idaho Code Section 74-124 exempts investigatory records compiled for law enforcement purposes when disclosure would constitute an unwarranted invasion of personal privacy. There we have that invasion of personal privacy again, because regardless of First Amendment protections and regardless of FOIA protections, the weight of personal privacy is always going to be tantamount. The statute defines unwarranted invasion of personal privacy as disclosure where release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against general public information. Idaho courts presume public records are open to disclosure, but recognize that exemptions apply when the statutory criteria are made. There's 2 cases right there that you could look up that support that. Now that Idaho has a statute specifically addressing autopsy photographs like Florida and California, autopsy records would fall within the investigatory records exemption when their disclosure would invade family privacy concerns. Okay, that's very important. Now, there's a couple of other things legally that I'd like to go over with you, and I'm sorry if it doesn't make sense, but I would like to go over a couple of things with you that I think are super important. And basically, essentially, it's that legal principles generally hold that traditional privacy rights, as in protecting a person's dignity and bodily integrity, cease upon death, okay? And no postmortem privacy right exists in the decedent themselves, okay? Surviving relatives, however, the surviving relatives may have distinct privacy interest in protecting them from the unauthorized disclosure of their images or information depicting the deceased, especially in cases involving egregious or offensive dissemination. That would mean something like an autopsy photo or an accident photograph, all right? And the courts have recognized these claims as protecting the mental and emotional well-being of the surviving family members. There's that thing again, mental and emotional well-being of the family members. Remember the rights of the individual, okay? Some states, such as Florida and now Idaho, have enacted statutes restricting the release of autopsy photos to protect family privacy interests. And courts have upheld such laws when narrowly tailoring the legitimate privacy concerns. Now, if you went to law school, there's narrowly tailoring, there's strict tailoring. There's a constitutional balancing test that every person who ever studied con law made 7,000 note cards, okay, to try to remember what the balancing test was. Okay, because each type of law requires this constitutional law requires a balancing test. All right. And in this balancing test, it has to be narrowly tailored to the legitimate privacy concern. All right. Notably, a constitutional right protecting a parent's control over dissemination of autopsy photos of a deceased child has been recognized in the Ninth Circuit under substantive due process relating to a family's integrity. Okay? Now, conversely, limitations on the disclosure of such images engage First Amendment free speech protections, making restrictions subject to those protections lead to careful constitutional scrutiny. Now, I know that sounds confusing because it sounds the opposite of what I just said, but follow along, okay? Courts balance a survivor's privacy interest against public rights to access and free speech, especially regarding truthful information lawfully obtained. Public interest in newsworthy information often outweighs privacy claims. However, courts recognize legitimate privacy interests of survivors against distressing or intrusive disclosures unlikely to advance public understanding. Again, here we go with the rights of the individual, right? We're talking about that dignity and that respect that I keep bringing up. Restrictions on disclosure typically require a compelling interest and a narrow tailoring, okay? Back to that constitutional balancing test, all right? And free expression remains a predominant policy principle. Regulatory efforts to prohibit publication of such interests face significant constitutional hurdles unless justified under a specific privacy or statutory provision, like the Idaho law, like the Florida law, and like the other laws we talked about in the other cases that I gave you as examples. Now, the key distinction in FOIA and state public records, those acts don't create an affirmative constitutional right to access government records. As courts have explained, while the First Amendment protects the right to publish information lawfully obtained, it does not require the government to provide access to information that is promptly exempted from the disclosure, okay? And that goes back to the Shuttleworth case. The press has no greater right of access than the general public to records that are exempt under applicable law. Again, the Shuttleworth case. Therefore, the statutory exemptions protecting family privacy and autopsy photographs do not violate free speech rights because they regulate government disclosure obligations rather than restricting what can be publicized once the information is lawfully detained. And that's where the free speech argument goes away. Okay? It's very important that you remember that. All right? Now, the real issue here is that we have crime scene photographs, autopsy images, graphic evidence, potential leaks, requests, speculation, and it becomes this sort of thing where we sort of have this argument between content creators and we have this argument between the press and we have this argument between the families where everybody wants everything all at once. And that becomes problematic, okay? Because do you really need to see an autopsy image? Do you really need to see that graphic evidence? And then if it gets leaked, what happens to it? Okay? This is not content-based censorship. Okay? The law does not say you can't talk about this case and you can't criticize the government. It just says the government does not have to give you these images. The government does not have to tell you or give you the information. The only thing being limited is access to sensitive records, okay? And that brings us to this, okay? What people are getting wrong. No one is stopping you from discussing the case. Discuss away. No one is stopping you from forming opinions, even if your opinion is stupid. No one is criminalizing speech, and this is not about you. This has nothing to do with you. The only thing being limited is access to sensitive records. Okay? And all of these people I see having this conversation about, well, it's not, it's okay that we're not getting these, but blah, 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 blah. It's okay that we're not getting these, but blah, 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 blah. Okay? There's no but. There's no but after that sentence. Regardless of how you feel about this, okay? What Olivia Gonzalez did is something that so many people in this world want to do, okay? She wanted a change in the world and a change in a law, and she was successful at doing it. And to hate on someone for doing that, and to do lives about something that she's done like that, and to do hours and hours of commentary about what she said and how it contradicts something she said before and how this sentence is different from this sentence and this is what she said then and this is what she said now. It's unnecessary. And quite honestly, it's disgusting. Okay? This isn't about you. This isn't about you. This is about families that are grieving and future families that will be grieving the loss of their loved ones. And this was done to protect them. This was done to protect them. It does not have to do with you. So just to go over the top legal points, there is no constitutional right to records. Privacy is recognized by courts, both state and federal, and the government can restrict access. Okay? Free speech protects your right to speak, but it does not guarantee your right to access every piece of information the government has. And when it comes to death images, we're talking autopsy, crime scene, this, that, the third, the law has constantly recognized that something else matters too. And that's privacy, dignity, and basic human decency. Not getting access to something is not the same as being silenced. And a lot of you get that mixed up. Okay? As someone who covers true crime, I totally understand the desire to know what happened, right? There are questions that I have about pretty much every true crime case that has ever happened. Okay? I have questions about every case. Okay? But that doesn't mean I'm going to get an answer. And that doesn't mean I deserve to get an answer either. Okay? I understand the desire to know what happened, but access to information is not unlimited and it shouldn't be. We've already seen in this case how quickly the speculation, the obsession, the misinformation, that can spiral. And adding graphic materials into that environment, it doesn't serve anybody justice. It just undermines it. So when people say this law violates free speech, violates FOIA, they're missing what it actually is doing. It's protecting the people in these exact situations where we're watching them play out in real time. If you can't see the pain and suffering on Olivia's face, if you can't see the pain and suffering on all the other families when they post about their loved ones, if you cannot see that these people have lost so much, then you're not looking. And it's hard to sit and watch that happen. Feel free to fact check me on the cases. Feel free to do any of that. But at the end of the day, this is an addition to SB 1250, and it is a welcomed one because other states have this too. And I'm not just saying that to make it right. I'm saying it because it preserves that privacy, that dignity, and that human decency that we all sometimes seem to lose when we're talking about cases like this. And I think it's something that we sort of need to remember when we're dealing with people who are suffering and are still mourning the loss of their family. So thank you for coming to my TED Talk. Make sure that you like and subscribe and comment, and I will see you on the next round. Thanks.